Good evening, everyone. My name is 𝗦𝗃𝗃𝗀𝗃𝗃𝗃 from 𝗘𝗚𝘃𝗂𝗃, and we have a very interesting session before us. Now, all of us present here must be aware that every day we read so many news articles about startups raising massive investments. Some are flourishing like an academy and Byju's, which are probably at the fifth or sixth round of investments, while some are raising massive investments for the first time. Now, it's very exciting to read about all of this, but something that goes missing is the understanding behind the whole dynamic between a founder and an investor, and what kind of discussions take place, and what are the do's and don'ts that are to be followed by either parties. We all know that this is one of the most in-trend areas of law, which is of interest to the legal and the non-legal fraternity alike. So the discussion today will be mostly centered around early stage startups, which require a lot of guidance to understand what is it that investors are actually looking for and what are the legal essentials to take care of. So to take the discussion ahead, and I have Mr. Arpit Ratan, lawyer and co-founder of Signzy, a fintech startup based out of Bangalore, and Mr. Chinmay Bhosale, lawyer and partner of SRB-OJAS, and also an investor. So this will be interesting because we have speakers from both sides of the table, and we'll be giving you a perspective from either side. Welcome, sir, to 𝗘𝗃𝗃𝗀𝗃𝗃𝗃, and it's a pleasure to have you both here.
Yeah, hi. Thank you for having us, and thank you for co-hosting this webinar along with.
It's an absolute pleasure over here, sir. And Arpit, sir, I must congratulate you for the recent surge of investments that Signzy has been updating. I think LinkedIn is filled with all the news articles, which makes it a very good point of time to actually have this discussion.
Yeah.
And Mr. Chinmay, sir, I hope that we'll also get like a counter view from your side as to what is it that investors are looking for and what is it that founders should keep a note of.
Yes, definitely.
So great, sir. Now that we have a couple of people who have joined us. Now, sir, if you could, Arpit sir, if you could just briefly explain to us what is it that Signzy does before we actually get to the heart of the discussion for today.
Yeah, so what I'll at least explain is about the Founders Project, because that is what
Absolutely.
is relevant to this webinar and how we came to this. So I think I consider myself very lucky that I was a lawyer before starting this company. And therefore, there are a lot of things which I knew from the start, things which I didn't have to depend on for legal advice or to reach out to law firms or to hire one. And especially when you're starting out and are very, very early in your journey, even before the first investment, every money counts, every single rupee counts. And while you're trying to raise your first round, you may not have enough money to pay for lawyers. What I came across when I started working in a technology company, which is a good learning for me, that the technology or the software world has created this community called open source, which means a lot of learning in software is provided for free to a community where people who are trying to learn, who are trying to do early stage work, can access free and good content relating to software development,
Right.
the open source community. And when I look back to us and a lot of my colleagues who are starting companies, founders, they were always struggling with this legal aspects of their business, legal aspects of the investment, and especially even if they were to hire a law firm, it was very expensive to hire a good law firm, which they could not afford initially in their journeys. So we started discussing around it, and with a lot of help from people and from investors like Chinmay, and we will make sure that we can get more people to join us in this mission and journey. The aim is very simple, is to create a sort of an open source community, which we are calling the Founders Project, to provide help from a legal point of view to things that may be needed for startup founders. This comes from my personal experience in being an early stage where you need help both legally, and you also need help in terms of just support. And the community would be, in future at least, the way we are thinking, would provide this support and provide this legal resource for early stage founders to at least balance it vis-a-vis the founder, vis-a-vis the investors who come with a lot of experience of investment, who come with the money, and therefore they can hire the best law firms. Therefore, founders are always at a disadvantage, at least in the early rounds. And this, I think, is something we want to balance out. We want to make sure that while making decisions, and founders are really smart people, but while making decisions, they at least have the best resource at hand, even if they don't have the money to pay for it. And that's what we're attempting to be. What we'll want is more and more feedback. This is the first attempt. We'll want more and more feedback so that we can fine tune the content we are building, and we can make it in a way which is really useful for the community that we are making it for. And we are wanting contribution from investors, and I'll let Chinmay also give his perspective. But I think the idea is to take contribution from as many people as can come on board. We are grateful that Chinmay has agreed to join us for the first one and to share his experience as well with us.
Yes, sir, absolutely, sir. So, Chinmay sir, if you could also add on to it from an investor's perspective, just to set the tone of the webinar.
Yes, absolutely. So essentially, as Arpit rightly mentioned, that it's necessary to help the community around the startups, specifically the founders, to drive them in the right direction, because essentially they are smart people with great ideas, but probably somewhere down the journey they get misled somewhere, or probably due to desperation for money, they might end up with wrong decisions being made. Having said that, I would also like to congratulate Arpit to come up with this great idea of starting the Founders Project, because it is something which is lacking in this industry, which I see from all the ends, right from the founders to the investors to even lawyers. So it's not that probably the lawyers would have a great depth of sense around the entire industry of how to deal with investors and founders, because this is new to the country in a sense. So making this relationship grow and making this community grow is a very pleasant idea in the first place. So that's a great way to go ahead with this. And I'm glad that I'm here to speak with everyone on it. And another thing that just to set the tone right, probably I would also like to pitch in is that to all the viewers, many times I've seen that, so why is this important is because it is also important to understand that the founders are more valued for themselves, their ideas and the people that they are, and they need not be flaunting unnecessary things which they are not. So why am I saying this is that, this is all about, 𝗏𝗏𝘂𝗃𝗲. I'm glad that 𝗏𝗏𝘂𝗃𝗲 has taken this up and taking up this webinar series for the Founders Project. But what this entire concept of Founders Project is all about is started by Signzy and is being headed by Arpit, who himself is, so I know this because being a lawyer, I've seen him right from the stages of not studying law and right from there to becoming a genius lawyer to a genius founder. So in spite of that, you will see that the person is unabashed. He'll still be the same person that he was as a student, then a lawyer, successful lawyer, and now a successful founder who has just raised in excess of $8 million. So many a times I've seen people, I've met founders who have barely an idea, not even a product, but they'll have certain air about themselves and around themselves. And probably that ends up in the wrong direction and doesn't help them getting the right investors or making the right decisions, legally speaking, because you come up with some air around yourself and unnecessarily it goes down in the wrong direction. So for such people who essentially are brilliant with their ideas but might not have the right guidance, I think the Founders Project is a very ideal position or ideal community to be in and be guided along with everyone. So this Absolutely. Is a great initiative.
Absolutely, sir. So thank you so much for this introduction to the Founders Project. And what essentially we'll be discussing in today's session of Founders Project, at least, is the discussion will be centered and divided into two parts. Firstly, the pre-investment stage, that when the negotiations are happening, what are the do's and don'ts that founders and investors usually follow and or should follow? What are the things that founders should know of? And secondly, like once the investment has been done, what are the issues that can crop up and how to best handle them? So before we start with the webinar, with the actual discussion, I would request everybody to post their questions on the chat box. And once we are done with the webinar and the content, we'll do like a Q&A session in the end where we'll take up all your questions. So guys, feel free to put your questions on the chat box. Now, with that, so let's actually start with the discussion that now, since we're talking about the pre-investment stage, where investment has not happened, and one of the basic questions that I think a lot of founders have, and even lawyers have, that what is the right time when startups should actually hire a lawyer or a law firm? Is it a blanket rule that once founders have come together to start a project, they should immediately start hunting for a lawyer? Thinking from a cost perspective, of course.
Yeah. No, I think that's possibly one of the most difficult decisions to make. To be honest, we didn't hire any law firm for our first round. We were lucky, of course, that I had some legal background. I was doing M&A in my own firm before we started this. So I had a very decent idea about what those terms mean. But even for an early stage founder, there are legal documentation that they'll need to sign at the stage of investment. And it usually starts with some term sheet. And I think that is the key. You don't even know whether you're going to get the money. If you do happen to hire a law firm, you will end up spending money which could have actually been spent building your product. You don't know after signing the term sheet whether you'll still get the money or not. Especially even if you're just negotiating, you sometimes may be talking to 2-3 investors. Right. And you may therefore be negotiating 2 or 3 term sheets at the same time as a founder. So does it make sense to get them all vetted by a law firm? I think that's a very important question. I have seen founders take 2 views. One, they've relied on self-learning, something like self-medication, where you Google a lot of these things and will try to negotiate yourself. And the second is that you will go to a good law firm and you'll hire a law firm and you trust their advice and pay them by the hour or whatever that contract will be. In my view, actually, depending of course on what kind of financial stage you're at, but assuming that you're early stage, you're still burning a lot and every rupee matters. I think both of these don't work. I'm completely against the idea of a founder doing a Google search and negotiating a term sheet, because I've seen a lot of times we coming across certain terms which are understood differently when they're actually applied, and which only a lawyer can, or somebody who has the experience, but maybe not a lawyer. At the same time, paying a lot of money for law firm doesn't make sense, because you don't know how valuable that would be, if you'll get the investment or not in the first place. And for example, if you're raising, let's say, 1 CR investment at an early stage, you don't want to end up paying 10% of that to a law firm. It's just not worth, depending on stage. I think what will be useful at that point of time is to talk to somebody who may not be a lawyer, but a mentor who may have done maybe a lot of rounds as a founder, as a consultant, as a CA, and you need those people to advise you on certain terms. I also feel that a lot of times a very open conversation to the investor on some of those terms can help exactly what do they mean, and clarifying them to the extent possible can also help. While as a legal community, I think I'm a lawyer myself, it seems very obvious that you should hire a lawyer when it comes to legal documentation. But I think why we are doing this founders project is that we find that there is this gap of, or an intersection between the world of founders and the legal, and we want to bridge that in between overlap, where yes, it is a legal query, but you need another community to solve for it. You need your mentors to solve for it. You may not be best placed hiring a law firm. The second option I've seen people take is hire a cheap lawyer. And I think there cannot be anything worse than doing that. You hiring someone who's not experienced, it's like if you want to, get an operation done, you won't go to a physician to do it, right? You need to go to the expert. And I think the worst is to hire the wrong person just because it's cheap. And that is disastrous. And maybe I'll let Chinmay come in with what the investor view is, but yeah, we can go into some of the details of how a bad term sheet can be really, really bad for the business. But yeah, maybe Chinmay can also come in and we'll can further elaborate on this.
Yes, sir. Yes, sir.
Yes, absolutely. So I completely agree that in spite of being a lawyer, I would suggest there's no need for founders to go to a lawyer at the very beginning just for the sake of it. As Arpit rightly pointed out, having a mentor, be it in your lawyer or anyone else, or I wouldn't say that it would be very, so it might be a good idea to find your mentor in your investor as well. Because essentially you are, you're going in for a marriage with the investor for trusting you and your idea and your company and trusting you with his money. So probably he's going to have your good faith at heart. And if you trust him enough, it wouldn't be a bad idea to have him as a mentor as well in certain cases. But essentially, yes, it need not be necessary to immediately run through the documents through a lawyer from the founder's perspective. But when it comes to investors, they obviously do have their own set of lawyers with whom they'll be consulting. Of course, with me, it is a bit different, me also being a lawyer who's been practicing for more than a decade. My office itself would take care of the documents that need to be done at my end. But that need not be the case with all investors. And in that case, they obviously have a lawyer and a law firm and an entire team behind it. And if you are going to get that ready help from their end, and they are also the ones with whom you can do back and forth and be clear about your concerns, I think that should be sufficient at an extremely early stage. Because you might as well hire a resource for your company with that money rather than spending an entire sum of 5 or 10 lakh rupees to do the documentation for an early stage.
Yeah, absolutely. So, which actually then takes me to my second question, that while looking for investors, sir, Arpit sir, what are the aspects that founders should actually care about, and what are the things that founders should not spend too much time focusing on? Like, since you were discussing about, how sometimes founders enter into really bad term sheets. So what are the absolute non-negotiables from a founder's perspective that way? If we could actually delve into this.
Yeah. So, I've been on both sides. Like I've been actually on the side where, we were as lawyers negotiating a term sheet. And when I look in hindsight, a lot of points we were making were irrelevant. Now, when I'm looking from a founder perspective, understanding the law, a lot of things are actually not relevant at all. But, some things are really disastrous. Like we got one term sheet in Signzy, where there was a clause that if you grow by 10x of the valuation you're today, then the investors have a right to sell your company or get it acquired. Okay. And, I think when you're early, you're also sometimes very desperate. Yeah. From their investors' perspective, for them, it is a standard clause. In fact, they said that almost every round that they, sign, they have this, and they said no one ever objected to it. Because they were very, very early stage investors. And possibly at that early stage, you kind of just feel if I grow 10x tomorrow, that's in any case a very good scenario. Why worry about it? Yeah. But I think it's the opposite. You need to think exactly the opposite. And that's what I spoke to them also. And we, of course, rejected that term sheet because they were not ready to back down on it. That if things are going well at that point of time, also you need certain protections. Yeah. When things are going really bad, I think that is when you should not actually stress too much on the legal clauses. If things are going bad, in any case, there is no value left for you. There's no value left for the investor. So if, let's say today, there's a company whose value is 100 million, and if we say tomorrow the value is going to be 5 million, or in a bad situation, very less, then discussing the legalities on it does not make too much sense as a founder. What makes more sense is if you're doing well, if you're growing, in that case, what are the restrictions that may come on you? That you should negotiate, that you should discuss out. That is something you should fight over. The second thing, I have seen a lot of people putting in their term sheets as investors is this tranche investment, and I've never understood it. So how it typically works is that an investor will give you a term sheet saying that I'm valuing you, for example, at 20 million, right? But you will say that half of the investment will come today, and half of the investment will come after a year if you complete certain targets or certain milestones.
Right.
I think this is one of the most unfair term sheets, and most founders should reject this outright. It does not make any sense until unless, of course, they're ready to renegotiate the valuation after a year. So, for example, I may be valued at 20 million today, or maybe less, and you're giving me a higher valuation, but I may be valued 3x of that after a year. And this is, in a way, a very unfair term to the founder, where the founder cannot increase the valuation after a year, but the investor can choose, depending on milestone, whether they want to invest further or not. This is where this is a typical investor bias term sheet. And I've seen a lot of early stage founders signing such term sheets, getting stuck with investors who they should not have been with. And I think as founders, when you're making choice of investors, a lot of these things are giveaways. The terms that are being offered to you as early stage, you should also judge your investor, that whether those terms are fair, because that is how that relationship will be built over the years. And therefore, a lot of things which the lawyer may feel it's fine, like this is one of the clauses I've never seen lawyers argue about, because for them it's completely fine, to be honest. But as founders, you need to think about your business and what impacts your business.
Absolutely.
Like typically that 10x clause, if you would have gone to a lawyer would have come back to him saying this is a commercial call, you make it. And therefore, my view is that at term sheet, you don't need a lawyer. You need a mentor. You need someone to tell you that this is not a standard term. Don't agree to it. I knew it because I'd been dealing with a lot of term sheets in my past, and I had an understanding that this is not normal. But you need somebody like that to come and tell you this is not normal. The investor is being unfair to you. And we can keep talking about it. Of course, we have a limited time. But I feel, therefore, as founders, when you're making choices, term sheets or terms in a term sheet, I think, are very important. Sometimes investors do put it, but once you have kind of pushed them back, and if they take it back, it's completely fine. It's fair. It's negotiation. But if you see a lot of investors sticking to terms which you feel are unfair, in that case, I think it's a sign. And as founders, while you may be desperate, where you might need business, but sometimes all money is not good money. So you should be careful that you're not entering into engagements with investors who are treating you unfairly.
Right. So on the same line, since you've already spoken about such clauses where investor might push for a tranche-wise investment. Now, if you're talking about the kind of rights that investors would want to have, especially while dealing with early stage startups, and Chinmay sir, I'll also come to you on this to get the investor perspective. But Arpit sir, what are the kind of rights that founders should make sure that they should not give away, especially if they're at that stage, that investors may push for? If, like, I think that's one of the most asked about questions, that how do we distinguish between what is the amount of interference we can allow or should allow from the investor side at the time of investment?
Yeah, see, at the end of the day, investment is a negotiation like every other thing. It's just a negotiation. Everything is out in the open. One thing I want every founder to understand is there is no standard. So I keep hearing a lot of investors insisting, founders, especially early stage founders, is that this is a standard term. like the 10x, the investors were adamant that this is a standard term. No other founder has, disagreed. This is what we have in all our agreements. I think as founders, we all need to understand there's nothing called a standard term. Everything is negotiable.
Absolutely.
It is your company. It is your shares to give. You are allowing them to invest in your company based on certain rights. And you have a right to choose. So don't feel bad or don't feel threatened or intimidated if you feel you are arguing for your company, because that's your right. You're not doing anything wrong to push back an investor because you feel that the right that they are asking is unfair. So there's nothing wrong in it.
Absolutely.
What I feel a founder has to choose for themselves, right? What is the value add that a investor will bring in? How important is the money to them at that point of time? Sometimes it's so crucial that you may agree to a lot more things. Sometimes it's not, and you may not agree to it. So a founder has to choose how crucial is that money at that point of time, at that stage of their company. From a perspective of bifurcating, I think there are two types of right that I've seen investors typically asking: the management rights and the rights to protect the investment. I think rights to protect the investment is something you should give, because that's the primary reason of investment. I think management right is something which you should definitely heavily negotiate, because it's your right to run a business the way you want to run it. So that is something that you should clearly protect. But there is no standard, there is no right and wrong. It would depend on the stage, on the need for the business for that money.
Absolutely. Now, Chinmay sir, I'll ask you the investor point of view. That what is it that investors are looking for? What is it that is absolutely a non-negotiable for them?
I'll break this into two parts. One is what would an investor look into a company before investing?
Yeah.
And second part, in what rights would an investor definitely would want while making his investment in the company? So coming to the first part, why am I differentiating the two parts is that many a times I have seen startups who are, so I can understand that at a very early stage, everyone is a bit cash strapped and desperate for money. But what happens because of that is that I've seen people take up around 50 investors for a tune of barely a crore or two. So everyone is investing 1 lakh, 2 lakhs or 3 lakhs of amount. And there's already a lot of ruckus going on with respect to the shareholders in the company. So in such a scenario, what happens is that if a smart investor is coming on board, he's not going to want a lot of clutter in the company already, because that is going to, so not for himself, but that is going to trouble the founder himself, and he might not be in a better position to run his company because of all the people that he has brought on board as investors. So that's one angle of it. And second, in the first part itself, the second angle of it is that many of the times I've seen that the idea is good, the founders are good, and it is an investable company per se, but probably the founders might be lacking experience for that matter in the sector, and they might be needing some sort of mentorship and some sort of hand-holding. So it may not be with every case or every company or every founder, but many a times this does happen. And as Arpit also said, that there's no set formula for it, but it all depends on, so what an investor will look at is, it'll all depend upon how the attitude of the founder is. Is he open to hand-holding whenever required? Of course, an investor is not going to come and interfere in the day-to-day matters, otherwise he would have started his own company with the same idea. So that is not his perspective. He's putting in the money because he's believing in your capacity and the idea, and he wants to just grow his money at that stage. So these two factors matter a lot, of course, other than the very basic idea and the potential of the founder while making an investment. So having said that, once that call is taken and while coming to actually deciding whether to make an investment, what would an investor essentially look at in the first place is protecting his investment. He's definitely going to push for clauses in the agreement which are going to protect his rights. So be it the right of first exit or be it the right of first refusal. Both of them are going to be really material for the investor while coming in and putting in his money. That being said, another right which is many a times expected by the investors to be protected is that of the valuation. Many a times it is very difficult to come up with a valuation at the stage at which the investor is ready to put in money. And at that time, he is going to expect that if a certain valuation is not decided, he can keep the shares as convertible shares and at a certain formula which is accepted by the founder and the investor. And he'll expect that whatever valuation you are getting. So for example, I have come in at a seed round and it's very difficult to gauge the valuation of that company. I can at least expect it in writing from the founder that whatever you will get at Series A, I should get a 30% discount over it while calculating my convertible shares. And that I would want it written in the agreement. Of course, the percentage of 30% or 20% or 15%, that's a negotiation at the end of it. But point is that I would expect that for that discount for coming in early, for putting faith in the company as well as the founders. And so those rights which will come, those clauses which will come with protecting the investment will definitely be looked upon by the founders, by the investors. As against that, ideally, I as a person do not really believe in taking over the management control or pushing over for management rights in the company. At best, what happens at times, and which is expected by certain investors, is that, and at times they are also right because they themselves are smart people and they come up with heavy backgrounds and they have heavy capacities to aid and help the startup as well. So in that case, it might happen that certain investors might ask for a advisory share, so certain share of the advisory shares in the company, or they might ask for a board seat, which doesn't really mean that they get the entire right over the management, but they would want an observer on the board just to check how is the company going ahead, and if needed, they can guide and help the founders and the other members of the board. So those are the essential parts which a investor is going to think of while going ahead with the investment.
Absolutely, absolutely. And so just to continue the question with you, that this is mostly for investors, that what kind of legal advice can actually become risky for the entire transaction, especially what investors need to be aware of, since it's usually the investors who are hiring the law firms and not usually the founders.
Usually hired. So what can go wrong, unfortunately, being a lawyer, I have to say this, is that many a times it is seen, I see this as a lawyer myself as well in negotiations, or I see this as an investor as well, that many a times if you bring on board a lawyer who doesn't really have the business sense behind the entire transaction, his insistence on unnecessary clauses might derail the entire investment or the term sheet. Because at times what happens is that if you go ahead with a very straitjacket formula, you might be pressing for certain clauses which are not really necessary or important in the practical angles of it, but are thought to be important from the theoretical sense of the legal field. And so practicality and theory need to meet with each other, and it's not necessary that you have a 100-page SHA to protect your rights. It is very much possible to protect your rights in a smaller and concise manner. And if that sense is taken by the investor, that of course he needs to rely on the lawyer for the documentation or the legal advice of it, but he should also understand that it should be merged with the practical sense of it. Eventually, he's there to put in money in the business, which is a practical world, and all that he requires at the end of it is a return for his investments. So if as long as you're sure that that is protected, you shouldn't be hooked up about making it difficult for the management or the founders to run the company and making it cumbersome on them to take the money. So that shouldn't be the angle at times, because that comes into picture, because if the investor is sound enough and if the founder is sound enough, all the terms as it is are matched by them before going to a lawyer. So there's not much a lawyer has to do. So at times it also happens that just to show that they have certain things to be certain inputs to be given, it might happen that they come up with a legal agreement which is absolutely good in the strictest sense of the legal world, but might not be necessary in the practical world. And that shouldn't make the investor derail the entire thing.
Absolutely. So if you could just give some examples, since people would ask that what are these unnecessary clauses that are not really required, just to give them a sense.
Correct. So, so as I said earlier, so one of the best examples would be the only thing the investor is going to care about is his investment being protected and his return being guaranteed. Guaranteed in the sense that he gets the first exit or he gets the first right of refusal if you're going to raise another round for capital. So once you have that, gunning in for other rights, like we want a board, we want a management control over it, and convincing the investor that since you're putting him in such a heavy amount of money, the industry, don't rely on them, try to have some control over the company. What if they run away tomorrow, etc., etc. Such things, if you fall for such advices and have those in your agreement at the very beginning, most probably it is not going to end up in a healthy equation with your founder. And if that lack of faith is seen at the very early stage, it's not going to end up in a very good journey ahead. So, and as I said, it's immaterial. So if a founder has to go go down a lane which is not really in sync, or which is not practically as well as morally right, and he's to siphon off money, for example, or if he's to do something untoward, he'll irrespective do it. It's not that an agreement is going to take care that he cannot do it, right? Yes. So why do you want to get into that picture and make it a very you want to make it a picture wherein the faith is lost at the very beginning, at the early stage at which the company is?
Yeah, absolutely so.
And another point that I would want to put in just before Arpit could chip in is that at least personally, I suggest that as a lawyer as well, and I look for it as an investor as well, is that at a very early stage startup, as an investor also expects, a third thing which I missed out, is that he wants you to value the investor for coming in so early. So you are an extremely early stage startup, completely agreeing to the fact that your idea is promising, but it is barely an idea. At times, it's not even a product if it's a product company. And if it's an idea, it's idea and a product which is about to enter the market, or it just has a potential. So if at that earliest stage, if someone is putting faith into you and giving you his money as well, then you should respect him equally by not going by the standard sets of formula of valuations. That no, I am going to charge you ABCD valuation, only then I want your money. I'm going to expect some respect by saying that is fine, but that would be if you are an established company, then yes, I would have given you the established norms of valuation. Today you are not, so I'm going to expect certain things from you.
Absolutely. Yes, Arpit, so if you could contribute over here from the founder's perspective.
Yeah, so as a founder and also a lawyer, I think from a founder perspective, and especially when you get lawyers involved, this happens a lot, I've seen.
Yeah, like when you have to deal with the lawyer of the investor side as a founder.
Yeah, I think, generally, yeah, exactly. So when a lawyer is involved, there are a lot of these clauses like indemnity, which, to be very honest, makes no sense in an early stage company. Neither an investor is going to ever sue a founder and its own company where they're investing. At the same time, I don't think for such a small amount of investment at an early stage, it makes sense for even the founder to fight too much around it. But yes, because as I think Chinmay rightly said, I've seen a lot of lawyers wanting to put their own weight on the table or put their own value add on the table. And there are specific clauses with respect to indemnity, material change, dispute resolution. And I've honestly never seen from an early stage to between a Series A, any company using any of those clauses. Again, it's not that it should be there, it should not be there, but I think this is something which both parties should be very, very flexible about. As a founder, you should not care too much about it, because if you come to a point where somebody can sue you, it won't matter whether you can. So typically people will argue a lot about what is the extent to which you can sue money. Now, the way, and I'm talking about Indian companies only, I'm not talking about companies in US, because a very different set of law will apply.
Yeah.
But especially in India, the average time for a contract dispute to get resolved is 4.5 years. Now, if you ever were to start that point, today like Signzy is 5 years. and we have come a long way, right? So I think there is no basis of an impact that it has on your company, and therefore for investor also it never makes sense, and for a founder also to make your deal stuck because of these things makes no sense. You should definitely negotiate on management because that affects your day to day. But things which are purely legal, I think as founders should not care about. Similarly, there's representations and warranties. I think it doesn't matter at all. At that an early stage, you really don't have any business. As Chinmay said, there's no business, there's no
Big representations as such.
Yeah, I mean, you should not argue about too much in it. It's going to get changed if you're going to raise the next round or you're going to go for Series B. Things will change in any case. But for a very early stage company, I don't think these things matter materially. As Chinmay said, if you do well, then you will have another set of investors, another set of term sheets, another set of agreements. But at an early stage, it's purely trust. And you should negotiate things which you think are very material. But just because the lawyer is pushing you on something, the other thing which I found very good actually, in my view, is to sometimes when you feel that you've reached an impasse with the lawyer, to reach out to the investor directly. Because a lot of times I've seen that these are sometimes purely lawyers' views. These are not even investor views, because investor doesn't care so much about it. But they have been convinced to the investor also. So, sometimes directly reaching out helps you to bridge that gap, break the ice, and at least make sure that you're moving the transaction in the right way, rather than getting stuck with the legal and arguing about a lot of these things which are legal and do not happen. And I keep talking about this whenever I was negotiating with a lawyer, that as lawyers, you're trained to always think about a probability of an event. Will this happen? And if this will happen, then I need this protection. As a businessman and as a founder, you think about the possibility of an event. Is this possible? And if you feel that this is something which I don't think in my business is going to happen, if investor wants that right, please give it to them. If you don't think that it's really something which is material to you. And I think at an early stage, you should not too much think about the purely legal clauses, which do not have any material impact on your business per se.
A lot of those clauses actually might just be inconsequential, and so absolutely so. So, which brings me to another very important thing that lawyers are usually stuck with, that is due diligence, which is the whole fulcrum of any investment there is. That everybody knows what is the purpose of due diligence, but then everybody, just like drafting a term sheet, follows a very straightjacket formula of making a DD report. But since law firms and tier 1 law firms have their own standard set for making one, but as a founder, what is your experience in due diligence, and what is it that actually is required? And Chinmay, I'll come to you as well, that what is it that investors are actually looking for while doing their due diligence, and what is it that can be done away with instead of like coming up with a heavy DD report and just kind of consuming time for both the parties. So Arpit, if you could share.
Yeah, so what I generally feel is that at early stage investors, they are very much influenced by VCs. Who rightly so have a good process in place to do their DD. They have a very structured there. But at an early stage, when the company is barely 2 years old, I don't think there's anything that a lawyer can do a DD on. Nothing really even exists other than the fact of the intention of the founders, which will never come up in a DD report. No lawyer can in a DD report decide the intention of the founders. And at that an early stage, to burden the founder and their business when they are maybe 10 or 12 people with that much of documentation does not even make sense as an investor. Because even if you're investing, I think investors should understand at that early stage, you are 12 people, 15 people, maybe 20 people. If you burden them with legal documents, eventually those will be done by the founder. So do you want your founder time to be spent in dealing with the customers, employees, product, or do you want them to be dealing with your legal due diligence questions? Because they will not have an in-house lawyer, they will not have an in-house finance, which means these questions will only be dealt by the founders themselves. So I genuinely feel at an early stage, there is no value in doing a DD at all. Forget what extent. There should not be any DD whatsoever. The whole investment is happening on basic trust, that you are trusting the founders. At a 2-year-old company, I doubt there will be anything which is going to come up, which you will be known in a DD report. The only thing possibly you should check is the financials, because you may be investing based on a certain financial
due diligence, most likely, legal due diligence.
Yeah, so investor may do their financial due diligence, whether if you're claiming 10 customers, whether those 10 customers are there, etc. So you may do a very basic financial due diligence to understand whether the business claimed exists or not. So business DD maybe yes, needed, but a legal DD, checking the employee agreements, contracts, etc. I think do not make any sense, and it actually ends up wasting a lot of time of the founder, which makes no sense for the business also. And things like whether I've come across DD reports where the team came out at very early stage that your agreements are not stamped. And I told the investor also that I'm not going to stamp them. I'm not going to waste my time, because we are not a 100 people company. We don't have an admin support. I'm not going to stand in a line for 2 hours to get a stamp paper. It makes no sense for my business. And these agreements are not even material. To the extent that stamp duty does not even go to the legality of that contract. And therefore, insisting on these purely compliance issues may make sense in a VC when you're a 100 people company. There are multiple revenue channels. There's so much that's happening. But in early stage, you're just trying to mimic and copy a VC DD. And I think it's just very time wasting for the founder and no value add to the investor actually.
This is a very novel thing I've heard, which is actually quite interesting. So Chinmay sir, what are your views on this? Because I know how much investors focus upon a DD.
Frankly speaking, I'll mirror Arpit's views on this in spite of speaking from the investor's perspective.
Right.
To be fair to your founder, at a very early stage, it doesn't really make sense in doing an entirely thoroughbred due diligence. What could be material and should be looked upon by the investor at best is financials and the customer base, obviously. But along with that, in certain startups, what happens is that they might claim to have a certain distribution network or something of that sort. In that case, the only thing the investor might look into in the due diligence is whether that distribution network, for example, is actually there. So say it's a chain of, say, fast food, and they claim that we have distribution in, say, 10 cities with 2 distributors per city, for example. It would make sense for the investor to check whether that actually exists before putting in the money. So beyond doing the basic due diligence around the business which is claimed by the
financial due diligence.
Correct. Yeah, or the legalities of it. So for example, it shouldn't happen that the founder has just come up with 10 relatives in 10 cities and saying that I have a great distribution network that I've set up.
Yeah.
So just to check that basic, just cutting the ice and checking whether it actually has any substance or it is just a bluff. That's the only basic due diligence which should be done at that very early stage, because beyond that, it's purely trust. Because what are you going to even get out of checking the employee agreements for that matter? What are you going to do if an employee agreement is actually breached? An investor doesn't have time to go behind every employee or the company that he invests in and checks every such thing which might go wrong in a company. So eventually, such things at a very early stage don't matter as much to the investor as well. They might matter at a very later stage when the money is very big, or probably the VC or the PE has to have certain SOP in mind while putting in such a big amount, because they are also answerable to their investors, which put in hundreds of millions of dollars.
Yeah,
so
absolutely.
there it does make sense, because they need those SOPs in place, and that's why that due diligence. But purely looking from the investor's perspective, whether it helps him, it doesn't really help him if you go into too much detail.
But sir, wouldn't they want to make a due diligence of, let's say, if this was like a fast food chain, so whether the required approvals and licenses are in place or not? Because wouldn't that go the route of their...
Absolutely. So that's what I said. You need to do the basic due diligence about the genuinity of the business. Okay. Whether the business is genuine. That I agree, completely agree. So if it's a fast food, as I said, if he says he has 10 branches or 10 distribution networks, sure, go ahead and check whether he actually has those outlets with the necessary permissions. But if you do a thoroughbred due diligence, it has n number of things beyond the basic agreements, or not even agreements, the basic requirements of doing the business. They'll go into the lengths and breadths of whether you have this policy, that policy, how's your agreement with your
policy,
with your consultants, how do you go about with your management, etc., etc. Those things are not really going to be of any material sense to the investor at that point of stage. And as rightly put by Arpit, it doesn't even make practical sense, like legal sense. Why would you want your founder and his team to run behind those getting the legal documents that you're pressing for? In all probabilities, they don't have them in place, and they'll run behind it and they'll try to make something which actually might risk you and the company by making a haphazard, fastly done agreement just to show it to you. You might as well trust the business and the founder if you see that the business angle of it is right, and you do that basic due diligence around the business angles of the startup.
Yeah, I think this is quite a new thing for everyone to know, because the general perception is that you should always have like a very heavy due diligence done of any startup that you're dealing with. So thank you so much, sir. We have primarily discussed the pre-negotiation and investment part. Now, if let's say we're talking about the post-investment stage, that the role of lawyers once the investment has been done, especially what happens when, for example, there is a dispute, and how should these disputes be dealt in the best possible manner, because we don't really come across a lot of news articles. I think the most publicly aware news article was with respect to the housing.com fiasco, where there was a huge impasse between the founder and the investor. But then we don't get to know of so many disputes that happen between founders and investors and how they're actually resolved. So Arpit sir, what is your take on this?
Yeah, again, see, speaking for early stage company, once you're at later stage, things can be very different because there is multiple things in your business that you want to protect. But at early stage, as a founder, I don't think you are in any case building a perception of a value that you have. There's no real asset. There is not any real money that you're protecting. There's a perception of a value.
Yeah.
And if you get involved yourself in a litigation, not only it is a huge waste of time in a country like India, of your founder time and of the energy and bandwidth that you have, but also it directly impacts your perception as a founder, as a company, to the outside world. And it's actually negative to you, whether you're right or wrong, but it's still negative to you.
Yeah.
What I also have seen a lot of companies, because I've advised them as lawyers and even now post as colleagues as within the ecosystem, I've seen a lot of founders who may be dealing with a legal issue for the first time do not completely understand that it's okay to let go. You may be right. You may be legally right. You may in fact have a legal right to sue. Somebody may have breached a contract, but every time that somebody breaches a contract does not mean that you have to go after them in a court of law. That's not mandatory. It's a choice. And especially in India, the amount of time and energy it takes in courts, it's just not worth it unless it is as fundamental as your core business. So if something is so fundamental that it can destroy the core of your business, then yes, please go to court. But unless it is so fundamental, I think it's just not worth spending your time, your money, your mental space in going to a court at all, no matter what it has come to. Especially, I have maximum times I've seen things getting resolved outside of courts in very good manners. You might need people and mentors to help you out with it. This may be one of the times that you also seek legal advice while you may not go to court. But this may be one of the instances where even as an early stage founder, you should take help of lawyers so that you don't end up doing something which you may regret. When choosing a lawyer, please choose someone who has a business sense. Your lawyer should not be pushing you to go to court. So choose them for their advice, pay them for their advice. Do not incentivize them to go to court. Otherwise, they will take you to court because that is how they will get paid. So therefore, select your legal advice well, or person giving legal advice well. But this may be a time that you actually need a legal advice so that you don't make a mistake if things do go to court. But in 99% cases, you should not do that. You should try to resolve it in an amicable way. Generally, as founder and investor, You both have the same objective. Your goals are same. So as long as both of you are achieving the same goal, it should be easier to come on the same page. But sometimes I've seen in startups, because of different reasons, there may be intention issues where the goals may become different and it may become necessary to go to court. But in such cases, you should take legal advice as soon as possible to protect your business per se, and not to gain advantage over them.
So then, pursuant to what you were saying, is there a need to actually redraft these standard dispute resolution clauses which exist in term sheets, for example, that, okay, courts of this city have jurisdiction and we'll go through arbitration? Like, would you suggest these traditional mechanisms, or do you think there is a need to actually change these the dispute resolution clauses specifically?
I mean, see, if truth be told, we had arbitration which came in, and then because arbitration was not working, then you had commercial courts, and now you're talking about a fast track court. I think eventually it is the civil court, whatever said and done, which gives you the final remedy, and then High Court and Supreme Court. And I think we're creating these layers and layers of dispute resolution mechanism. But end of the day, if you are going to go to litigation, you're going to go to it. Period, right? I mean, whether you're going to do arbitration, whether you're going to go to court, whether you're going to do something else, if you're going to go into litigation, then I think you've already reached a point where you feel your core business is getting threatened and you want to go to court just to survive, just to make sure your business survives.
Right.
Now, at that point of time, I feel it won't matter what you've signed up, honestly, in your agreement. It is that point of time where something so fundamental is wrong that your agreements will not matter. It will be more of intention issues. And there may be different remedies under different clauses. Personally, I feel that you should not argue too much on dispute resolution, because even as founders, it does not put the right foot forward. As a founder, if you're discussing or arguing too much on dispute resolution and indemnities, it just doesn't send the right message.
Yeah, kind of discourages the investor as well.
Yes, it does, right? I mean, why would you be so worried? I mean, in 99% cases, it should not happen.
Like, so, I really like the phrase you use, that differentiate between possibility and probability.
Yeah, correct. Absolutely. As a founder, I mean, if you reach the point, in any case, it's not going to matter. I mean, in any case, it's a downhill. Then Absolutely. You're just trying to protect whatever is left of your business. In any case, it's gone downhill. So don't worry so much about it. Protect, or try to, when you're negotiating, try to make sure that you're building enough trust with your investor. So negotiate on things which may restrict your business, like the 10x clause. It restricts your business. Yes, argue about it. Maybe board rights, argue about it, because it's something which will restrict you from running your business. It's your right. So argue about things that you feel are important to you as a founder, as a business owner. But things which are more legal, I don't think a founder should at least argue too much about.
So, Chinmay, I'll ask you the same question, that while discussing the dispute resolution mechanism, what has been your experience, especially once the investment has been done, but some disputes are happening? What is the best possible manner in which both parties should, like, so has already said that courts should be tried and avoided. But then if that is the scenario, what is your take on the mechanism that should be followed?
Most definitely the court should be avoided. There's no doubt about it. And personally, I also believe that the alternative dispute method of arbitration should also be avoided. It ends up being a fancy litigation, nothing beyond it. And you end up challenging the arbitral award any which ways. Exactly. I've rarely seen anyone going with the award in the first place. So when it comes to dispute resolution, I personally prefer that the issues, whatever issues are there, should be mediated or negotiated across the table by the founders and the investors. If necessary, do also have a mediator or your lawyer with you for those mediations and negotiations. But it makes best sense to iron out those differences without going in for litigation or arbitration, for that matter.
Right.
With regards to the second point that you mentioned, whether those clauses should be changed in the agreement in the first place or not. Even though I agree what Arpit is saying, that eventually it doesn't matter because it's taking you down the hill. If you're going into dispute resolution, it means you have not ironed out your dispute in the first place.
Okay.
But nonetheless, what I feel is that that should also be brought into the clauses. It does. So I've seen, so as a lawyer, I've seen it help quite a few businesses if the clause itself mentions that before going in for arbitration, let's have a negotiation, and you mention the methodology for it, which is mutually agreed by both parties. And I've seen, so if not very early stage startups, I have seen good businesses benefit out of it, because eventually, if you see it specifically, the people who are getting into business now, the millennials or the people in their 30s or probably even in their 40s, the intention is not to go and fight. The intention is just to do business. There might be differences, but there'll always be ways to go beyond those differences, because eventually a founder would want to do business, an investor would want to make money. Of course, he's making money and he's investing, means he himself has a setup of businesses or whatever it might be from which he's earning money. So he also values the concept and the idea of keeping the business running. No one is going to come up with the intention and idea that I want to hamper everything and make sure that it goes to court and everything is just stayed and it's stagnant. So that shouldn't be the approach.
This is actually quite a progressive thing to say, that in your clause itself, give a methodology that before going to arbitration, explore these options or go through these options first, and a much cheaper and faster resolution, definitely. So thank you so much, sir. I think we're also like kind of nearing our closing time, but I think this was a very fantastic introduction to the series as to what is a dynamic between a founder and an investor. And we have 2 questions from Udit over here. Arpit sir, the question is for you, because while you were explaining the 10x issue, they couldn't understand the issue properly. That, sir, I want to ask, what was the 10x thing which you said will make the investor sell the company? Can you please explain that? And is there any right that is there in a term sheet that an investor can even sell the company? So if
so typically the right was that if the valuation, so as Chinmay was saying, right, so the investor will ask for their exit rights. Yeah. And one of the rights that they had asked was that if company is, for example, being valued at 10 million today, and if tomorrow the valuation reaches 100 million, in that case, the investor will have a right to sell their stake and to tag along all the founder shares, right, which is in effect an acquisition of the company by anyone else. Typically, this would be done by competitors who would then see you, like Facebook acquired so many people, Google acquired so many people. Typically, this would be not an investor, another investor acquiring you, but typically this will be a competitor who will be acquiring you. And I mean, this is one example, and there are multiple such examples where the investor would ask for a tag along of the founder shares, and tag along of founder shares in effect means an acquisition, means that the company is getting acquired because you're holding majority. So investor shares plus founder shares would form a majority of the company, which means it's an acquisition.
Absolutely, so absolutely. So yeah, I think this almost brings us to the end of our webinar, and we have another webinar starting in 10 minutes. So guys, if there are any other questions, please feel free to share, or else if you guys want to ask questions later on, do share them with me, and I'll definitely try and get the answers from sir over here. So Arpit sir, Chinmay sir, thank you so much for taking out the time, especially on a weekday evening for this particular series. And we're very excited to actually and we're looking forward to the upcoming sessions on this particular founders project, which I'm sure will actually be very, very helpful, considering we've had such a brilliant start today. So thank you once again, sir, Arpit sir and Chinmay sir.
Thanks the team at 𝗏𝗏𝘃𝗀 for hosting us, for doing this with us, and for contributing to the founders project. And hopefully we'll be able to build on this.
Absolutely.
And something which will help the founders eventually, because I think something which is really needed in our country right now.
Definitely. So thank you everyone for being a really patient and kind audience, and we'll see you for the next webinar, which will start in around 10 to 15 minutes. And good evening. Thank you so much. We'll see you next week.
Thank you.
Thanks, sir. Thank you, Chinmay sir. Thank you, Arpit. And thanks to the team of Signzy for actually helping us organize this.
Thank you.